Hello, everyone. Welcome to this very special edition of the Domain Name Law Show. Today, my co-host Jeff Neuman, David Michaels, and I have the pleasure of speaking with a true domain name law academic. It's my honor to welcome you, Jerry, and to introduce you. Our special guest today is Mr. Gerald Levine. Mr. Levine is a New York City attorney. His practice area includes trademark infringement, copyright infringement, and domain name disputes. He's a UDRP panelist, a UDRP scholar, a fantastic writer. His latest book is The Clash of Trademarks and Domain Names on the Internet. Mr. Levine, thank you for joining us today. How are you?
Thank you. I'm happy to be here with everyone.
Well, we've had a chance to say a little bit of the greetings, but the guys, the co-host, Jeff and David, can say hi a little bit more when they ask their first question. I wanted to jump right in because today we were going to talk about really first your book. Second, really some of the representation that you've done over the years in the domain dispute space, and then some general questions. But first, Jerry, I wanted to ask you, on your book, the title seems pretty self-explanatory, The Clash of Trademarks and Domain Names on the Internet. But if you're speaking to a person that's not a lawyer and they ask you, what is the book about? How do you describe it?
Well, there are statutory rights, trademark rights and statutory rights. And there are other rights that the domain name registrants have, and that's recognized. Each has rights. And there's a clash of these rights. In the domain space, approximately 90 to 95% are cyber squatting. There's no doubt about it. They're actionable claims. There's no defense. But for about 5% of the claims that are made in the UDRP, which amounts to about 300 decisions a year, there's a real conflict. There's a real difference in the facts that domain registrants have rights. It's not an issue of better rights for each party, but they have their own rights. The irony in all of this, in trademarks, is that while a trademark registrant owns the trademark, it doesn't own the name. It doesn't own the name. It only owns the trademark, and that's the clash.
Well, Jerry, thanks for mentioning that. That was one of the comments that I had, that you've said trademark owners own their trademark. They don't own the word. And you've already brought that up. I wanted to ask about the book. So I'm reading the book right now. It was interesting because I believe it was Zach Muscovich asked me the very first time, so what interests you in domain name law? And I was thinking, I'm a business person. I have domain names. So of course it interests me. But then, a little bit more, I'm interested in law, and I went to law school for a few years before I took a right turn and didn't go back. But so I was going to mention who was this? I'm reading it. I'm enjoying it. I like your writing, Jerry. I think it's fantastic. And I really mean that. And I got some excerpts to prove it. But who was this book written for?
Well, it's written for, it's obviously written for practitioners, for trademark owners. It's written for representatives, both of trademark owners and of domain name registrants. There isn't, or there wasn't, and I mean now that the ICA is doing the digest and so on, there's much more information about what the UDRP is all about, but there really isn't enough information about the claims, about actionable claims as opposed to non-actionable claims. And I think, it's difficult to know fully who the audience is. But the potential audience is very significant. I don't know whether, that everyone gets to see the book or to hear about the book, but it would be. Well, I'll get to it later, but it's probably a smaller audience than it would be if the book were directed only to lawyers.
Well, the book, I think domain name investors would really appreciate it. You go into the secondary market, the development of the secondary market, and
Right.
how important that has been. And that means, it's very interesting to people that have domain names. So before I throw it to my co-host to ask a few questions, I wanted to ask you, so, I've been practicing that intro. That wasn't written down, I got it written down, but I practiced that. So I know that. But I was always messing up saying the clash of domain names and trademarks on the internet. I always use domain names first because I love things alphabetic. But why did you choose to put trademarks first? I mean, just the title, or was it because trademarks came way before domain names? How did you select the order of the title?
Okay. The UDRP, WIPO, the World Intellectual Property Organization, is really investigated and created the basis for the UDRP. The UDRP is basically a protection for trademark owners, and that's why it comes first. I should say that in the congressional complement to the UDRP, the ACPA, the Anti-Cyber-Squatting Consumer Protection Act, the Senate specifically explained that the UDRP, although it protects the statutory rights, also respects and protects the rights of domain registrants. So that's the reason. Also, I mean, of course, trademarks is an ancient protection of rights, product rights, service rights.
I really like the congressional complement. You calling that the ACPA, the congressional complement to the UDRP. Jerry, for those who are interested in getting your book, they can go to dnlshow.com. That's our website for the show, and I have a link to Amazon where they can buy the book. It was the foreword that Georges Nahachavansky had written, and I wanted to read just one thing, how he summarizes what the book is about, because it's pretty fantastic. His foreword to your book. I just want to read for everyone. Clash is an important and authoritative resource on domain name law. It certainly provides the type of information and analysis needed to successfully represent clients when enforcing trademark rights or defending against a claim in a domain name dispute. So it's that and so much more, but really he does say it nicely and concisely right there. And your preface, you have some, an interesting quote about, your reason for writing the book, and then the ability of people to register domain names anywhere, and they have to be wary. But I'm going to mention those quotes in just a minute. But first, I want to throw it to Jeff Neuman, one of my co-hosts. And Jeff, you want to greet Jerry and have a first question for him? Have at it.
Yeah. Hey, Jerry. Good to see you.
Hello, Jeffrey.
Yeah. I mean, I wanted to because I have copies of Jerry's books, and this first one, the domain name arbitration. Jerry wrote a first volume, I think, and correct me if I'm wrong, it was like 2015. And then a follow-up was 2019. So, which provided more updated cases and things. So I guess my first question is, you decided to write this book, The Clash of Trademarks and Domain Names, instead of doing kind of a third or a second update or a third domain name arbitration book. So can you just go into maybe a couple of reasons why you set out to not just do an update of domain name arbitration, which a number of us practitioners, panelists, and I see a couple others on here as well, use all the time. Why did you decide to write this other type of book as opposed to just doing kind of a third or a second update to the original?
You know, Jeffrey, it's a difficult question. So I thought let's call it the yellow book. First of all, there was the blue book, and then there was the yellow book. And I thought that it really required a different approach. And the clash of trademarks and domain names was an attempt to go behind, in essence, WIPO's overview. It was intended to sort of strengthen the reasons for the authority that it developed over the years. So let me start. I didn't really focus in the yellow book. I really didn't focus on this issue. When UDRP was implemented in 1999, there was no law of cyber squatting. There was some emerging law from U.S. courts. I don't think there were any other courts that really decided any cases. There was one case from the U.K., but there was no law of cyber squatting in the arbitration regime. And we know that from the first few cases, they were citing U.S. law, not as precedent. They were citing it. Oh, this conforms to what we think the principle should be. And over a period of time, let's call it 5 years, there was various responses to various issues, numerous issues that came up, various responses. And among them, very authoritative decisions with regard to the jurisprudence. Those, and we're going to be hearing from Tony Willoughby on Thursday. Tony, and among others, in the first generation of practitioners of panelists, through their this very distinguished and very authoritative responses to the issues, started jurisprudence. Now remember, no law, no jurisprudence at the beginning. Jurisprudence develops slowly over time. The clash of domain name, of trademarks and domain names is an attempt to demonstrate the development of the jurisprudence. From nothing, it slowly develops. In 2005, you get WIPO first overview. There are obviously differences of views expressed in the 2005. The law develops further. I'm talking about the law, the jurisprudence develops further. You get a second overview in 2011 that seems to recommend or to add to the jurisprudence. Some of it was good and some of it wasn't good. And by 2011, some of it that was not good was discounted and basically dropped from the jurisprudence. So what I'm demonstrating in the is something that I didn't do in the Yellow Book, which was of a jurisprudence. And that's what makes, and that's the difference between the Yellow Book. I didn't think it was necessary to do another edition. I thought this extended the argument into the jurisprudence and demonstrated that there was a jurisprudence now. And you may ask me, one of you may ask me later, well, what difference did it make? Well, it makes all the difference in the world. It means that the panelists have law to follow. And that's why in many instances, and through ZAC and the ICA digest, we get discussions about sloppy reasoning, bad decisions, good decisions. In yesterday's, or I guess it's today's digest, we have discussions on very good decisions that were made. This is very good. I don't know whether that answers the
absolutely. I think you really covered the part. The reason why I love the Clash book, because it does go into more of the rationale, not just the fact that cases came out a certain way and what they stand for, but why they came out in a certain way and relating it back to the original intent. And I was around, as you know, back in 1998, 99, and was on one of the committees that helped kind of come up with the UDRP and discuss the principles. And we discussed back then that we really weren't intending to create this new system that had precedent and everything, right? That's one of the things that I think early on we maybe was an error on our part, or just wasn't forward thinking enough on our part. But we didn't want to create new law at the time. But now looking back, 25 years, more than 25 years later, we realized that, the precedent that has been established, which you discuss, is so important. And so what is it in your view that, as you said, before 2011, there were some interesting developments that started to creep in decisions that did not become favored after 2011, things like retroactive bad faith and some other things like that. So what is it, given that there's no kind of statutory law, real statutory law, what is it that keeps panelists, in your views, what is it that keeps them following precedent? And what is, what is the element that some people say or believe that they have the ultimate discretion and could decide anything, any way that they want, even if it's in an arbitrary manner? What is it in your view that keeps panelists following kind of the consensus view?
Okay, so WIPO, in its overviews, says that it's not it's not a presidential regime. And in a sense, it isn't a presidential regime, but it's an authority-based regime. It's an authority-based regime. So what keeps panelists in line is, as you know, they're always citing cases, and the cases they cite are what they regard as the authority that underpins or underlays their decision. So it's authority based. But the irony, at least I find it somewhat ironic, is that the is that the 2017 overview is called a jurisprudential overview. So WIPO, I mean, in a sense, WIPO is saying with its left hand that there's no precedential, and then on his right hand it's saying that there is. It's very strange. But in the final report, the WIPO actually looked forward to the development of the law. And out of all the decisions that are going to be made, law would, I forget the exact words that the WIPO used, but it was clear that they anticipated there would be a development in the law, so that everyone knew what they were getting into. I mean, if every panelist were to simply make a decision based on what it thought the outcome should be, you would have no law. You would just have people. Everything would be one off. And I know that there's always this discussions about this. What practitioners, what lawyers, what litigators, because although this is an arbitration, but I always think of arbitration. Yes, it's arbitration. I've done arbitration. I've been on arbitration panels. It's litigation. You call it arbitration. It's litigation. Everyone, you have to prove your case, and you prove your case with material evidence. We know that there are cases in the UDRP in which there's a sort of an ignorance or an ignoring of material evidence. When you draw implications from the facts, if the material evidence is incomplete, you draw an inference about a party, either the complainant or the respondent. You're making an error, that kind of thing. And you're making, well, they don't know they're making an error, but we know that they're making an error because they're not following the law. And the law is what, in 25 years, everyone, or most everyone, agrees to follow. So if it's not presidential, it's certainly authority-based regime. And that's, you look for, I know Jeffrey, a terrific writer and panelist, and Steve, I see other people here who are in, the panelists. You look for the authority and you cite it. That's where it comes from, Jeffrey.
Yeah, great. Thanks, Jerry. And I want to throw it back to David. Hopefully you've got see you, David. So great. So let's throw it over to David.
Okay,
Great.
David.
Hi, Jerry.
Don't throw me zingers.
I have a question.
Okay.
Should panelists apply the law of the jurisdiction where the respondent is regarding their divorce?
Okay, David, you're breaking up. Start again.
Okay. Should panelists apply the law of the jurisdiction in their neighborhood, in their country,
No.
in determining legitimate interests?
Yeah,
No, no.
that was a verbal on a no.
Tell me when to talk.
Go ahead, Jerry. Go ahead, Jerry.
No, the law that is applied in the UDRP is the law that's developed within the UDRP. It doesn't make reference to US law. It doesn't make reference to Canadian law. It is a law that's developed. There is perhaps one area where panelists are likely to apply the law of the jurisdiction in which the parties are located, which is fair use, constitutional protections. But in all other respects, and there may be one or two other issues, but in all other respects, you apply UDRP law.
Okay. And what are the big differences you've seen over the last few years in legitimate interests?
Well, as I say, it's constitutionally based. For example, criticism in the 2005 overview, you had a difference of opinion, and they called it view 1 and view 2. If you have trademark.com and it's a criticism, basically European practitioners were unconvinced that this was that the respondent was protected, irrespective of the content. American practitioners applied the First Amendment. It didn't make any difference if it was trademark.com or it didn't make a difference that there wasn't an additional word added to trademark to indicate that or to advertise that it was something more than just taking advantage of the trademark only. I mean, it's very simple. I think even now, David, there's the split that was demonstrated in 2005, which appeared to be harmonizing over the years, I think is again, and there may be some, further discussion on this, but American practitioners, I think, will still go with, regardless of the name of the domain, regardless of the domain name, whether it's just the trademark.com or trademark plus, they will go with American law.
I have a question related to this, and then we're going to get to some talk about PPC Landers. But Jerry, I wanted you to know that I did have on here. You said UDRP decisions may not hold precedent, but they do have authority. We just went over that, so I love it. I mean, I was right on.
Yeah,
okay,
yeah.
About this question, as a panelist, when a respondent says to you, they're using someone's mark, they admit it, we're using their mark, but we're using it in fair use. What do you need to see from them in order for them to deny the complaint? Meaning, people claim fair use, but what do you really need to see from a respondent who claims it?
Well, on the constitutional law side, I mean, it's more obvious on the constitutional law side. You look at the content of the criticism of the commentary, whatever it is, not. I mean, you just need to see that it's that it is what it says it is. The panel isn't there to make a determination as to whether or not, for example, it's defamation or anything like that. So I won't go further into that. But we have another theory under fair use, which is called nominative fair use, which allows a respondent, and this isn't incidentally, when we're talking about nominative fair use, we're not talking about investors. We're talking about other businesses that are using, that incorporating into the domain name, the trademark. There's a well-respected, let's say, authority that sets out the terms of nominative fair use. When it was first expressed in a case called OKData something.com, I forget, it didn't make reference to US law, but in fact, US law was already developed in the nominative fair use area. So I don't know whether Todd, whether that answers the question.
Yes, no, and thank you. And it was about my question was really about nominative fair use, and you touched on that. I wanted to, since we're going to shift to PPC Lander pages. The reason I bring that up, I know Jeff has some questions, but you told me a couple weeks ago you arranged for a domain to be transferred because it had PPC Landers, and you felt that was the appropriate move for that particular name. But why did you feel that for that? Explain that issue that you dealt with, please.
Okay, so I should. So I represent NameFind, which is GoDaddy, and for the last 8 or 9 years. From time to time, GoDaddy sends me either a copy of a complaint that has been filed, WIPO, or is generally WIPO, but it's sometimes form, and ask me to make a determination as to whether or not they should defend it. And when the claim is defendable, I defend it. I've had about 20 of these, I don't know, over, as I say, over 8 years. So it's not, they don't get a great number of those cases. But they do get cases that are indefensible. So GoDaddy, which is probably one of the largest, maybe the largest investor portfolios, buys over the period of time, over the last 16 years, has bought portfolios. And those portfolios contain domain names that are obvious, cyber squatting. And when those cases come in, I evaluate them. I decide whether they can be defended, they can't be defended, they can't be defended, and they're WIPO. I just send an email to WIPO. We're not. I'm going to settle this case, and I'll contact the adversary counsel, and we always come to an agreement. We settle it. That is, the settlement is simply transferring it to the complainant's account. In 1 or 2 instances, and this is from not only my experience, but experience of other attorneys, other representatives. In 1 or 2 instances, and this is always from a Canadian lawyer. I forget the name of the law firm. It's a big law firm. They only sign it with the law firm. They don't sign it with the name of the lawyer. who demand, yes, we'll settle the case, have to pay us attorney's fees, send us $10,000 and the case is settled. Fuck you. So I always do, I mean, this only happened a couple of times, send a, respond to the complaint, attach all of the correspondence with the attorney and say, we told them that we'll we'll just transfer it. and the panelists always both parties in words of substance, both parties wanted to be settled and transferred, and they just put their rubber stamp on it without going through any analysis of cyber squatting.
Well, Jerry, thanks for sharing that about the portfolios that get purchased too. It makes sense. There's a lot of, as you and I talked about, dead weight. There's some things in these portfolios that, like you say, are just flat out indefensible. And GoDaddy wasn't picking them up because they thought, yeah, we want that name. It's part of the portfolio. But yeah, so I'm sure they get just as many UDRPs that are indefensible as they do that are defensible. Am I right there?
Right.
Okay.
Yeah. But I just wanted to make, just let me add sort of a footnote to this. The last one that I transferred, and this is another great irony, and I don't think it's just GoDaddy that does this, but they put it up with some links, and I know you want to ask a question on links. They put it up on links. So this last one is in the I don't know, in the fashion area, but the name of the trademark is a family name, which is a fairly rare name, but nevertheless is a family name. The irony is that if they hadn't put up the a website with these links, and the links going directly to this fashion, it would have been a defensible claim. It would have been a defensible domain name, and I think quite valuable. But they put it up with links. Now, if the links had, there are cases in which the links, because GoDaddy, and I know Jeffrey is big on this, GoDaddy puts up the links, but the trademark is, fairly generic or fairly descriptive, and the links go to fairly generic or fairly descriptive. That's not a problem. The problem is when the links go directly to either to the trademark owner or to its competitors.
And that's a perfect transition for my question, right? So it's one thing, right, when GoDaddy, for the names that it owns, right, for names that are its portfolio, puts up links, right?
Yeah.
So that's the scenario that you've been talking about in general and defending. But in your view, and it's not just GoDaddy, so this is not just picking on GoDaddy, but maybe I'll go back a little bit. In like the mid, 2005 to 2015 or so, it was pretty clear that when someone put up links on when you went to a domain name and you saw links there, 99 out of 100 times it was put up by the registrant because they were trying to get search engine traffic and all these other things. So in those years, a body of law, authoritative law, developed that said, having PPC links up on a site could be a negative factor against you in reviewing bad faith, right? And so that became generally accepted amongst panelists. But I think we've seen technology in the past 10 years or so, or different developments where oftentimes the links are now not put up by the registrant themselves, but are part of a default page that a registrar has when someone registers their name, but has yet to change the name servers over to, you know, whatever they ultimately want to use it for. And so I guess my question is that, you know, there are some panelists, myself and Steve, as you pointed out, we understand the new technologies, and when we get cases like this, we do look behind, you know, how the links get put up on the site, and whether it financially benefits the registrant, or whether it is something that by default that, you know, a registrar puts up there. But we've noticed that most panelists, either because they're not educated in the area or because they're just relying on the that was developed in between 2005 and 2015, you know, are still finding bad faith or using PPC links against the registrant, even when put up by the registrar. So I was wondering what views you have as to, you know, what panelists should be doing in terms of evaluating those circumstances. And two, what is it that should be done in order to reach the panelists to make sure that they're educated and understand more about the technologies in which they are deciding these cases on behalf of, including things like the changes in PPC links when they are either cookie-based, you know, placed into the browser, or geographic-based. So I know that's a long, long question and a lot of developments.
Well,
Trying to boil it down is hard.
look, I think you sort of answered the question as you went along. There was a body of law, I think, that was building up, that it was a principal factor in finding bad faith. But I think that's been attenuated. Over the years, and particularly over the last 6 years, it's a factor among others, as opposed to the factor. That's what I think is going on. But there was also I think, you know, in the ACPA, it may have even been in a GoDaddy case. There was an issue as to whether or not it may be the Dent case, it was lotto.com in the UDRP. It was appealed, quote, appealed to the ACPA. And one of the issues, obviously brought up by the trademark owner, who is now the defendant, argued that there was clear cyber squatting because there was some of the links linked to the trademark owner. But the district court said that's, you know, that they looked at the registration agreement. They looked at the GoDaddy service, whatever it's called, Jeffrey, and they said it was put up by GoDaddy. It wasn't put up by the plaintiff. And summary judgment was issued in favor of the plaintiff, who retained control of the domain names, two domain names. So my sense, Jeffrey, and I think this is your sense, that it's now just a factor among others. And in fact, in a case that will probably be published tomorrow, in which I was a wing, the issue actually arose. And the panel had to deal with it. And the panel said it doesn't make any difference. It's
So
a one-time deal, and it's as soon as they were told about, as soon as the domain registrant, an investor was told about it, they took care of it.
So on that, getting a little bit more to the general, how do you think over the years the UDRP has dealt with changes in technology? In other words, I'm trying not to give away an answer here, but we have a UDRP now that's 25 years old, and in those 25 years, there have been a lot of technical changes. So in your view, has the UDRP been effective in dealing with technological changes?
Well, you know more about this area than I do. There, you can find out whether or not the domain registrant is using emails, for example, the MX. And I guess over a period of time, we panelists have become familiar with this as a factor to be considered in whether or not in determining bad faith. I'm not as current as you are in the technical area but if there are authoritative decisions, as there have been, and I think one of the two of your decisions has delved into this, I would look with respect to those authorities.
Yeah, I mean, I guess, as a positive, real positive, look, the fact that it's lasted 25 years throughout all the technological developments means that for the most part, the UDRP does, kind of withstand the technological developments. And yes, there are many outliers. There are some outliers, but in general,
Yeah.
I mean, we developed a pretty effective system that's been able to so far survive through,
Right.
The world's a completely different place than it was 25 years ago, but yet the UDRP is still here. And maybe this is sort of a transition to, are there some changes that you think would be beneficial if we ever do get a UDRP review? Are there certain things that you would like to see changed with the UDRP, even if minor? What kinds of things would you like to see as we look towards the future?
Oh, Jeffrey, this is such a large subject. I would defer to my friends Steve and George and Zach and Nat Cohen. I endorse that the group has created suggestions, proposals. They're not so much their procedural issues. I endorse a number of. I endorse the procedural issues that have been advanced in this area. But the only one that would particularly interest me, because I'm doing a lot of work with the Anti-Cyber Squatting Consumer Protection Act, is appeal. And whether or not we should have a regime within the UDRP for an appeal, and I think that deserves discussion. How it can be done, who pays for it, and so on. There's a number of issues There are not, and including some procedural issues. If you go to if there were such an appeal within UDRP, does that foreclose going to the ACPA afterwards? Which I think it would. But all of this, is a part of a much larger discussion. As a general overview of it, I would, for example, the and/or issue. Right now we have a conjunctive requirement, evidential requirement. Should it be or rather than and? That kind of thing. And my response is that you can't do it. You can't post hoc change the law. The interesting. I know, Jeffrey, you talk about statutory. The UDRP is a code equivalent to a statute in a very important sense. It's a code. This is what was expected. It's a code, like a statute, is a guidance. And just like the ACPA over the last 25 years has developed a jurisprudence in the ACPA, so has the UDRP its own jurisprudence in cybersquatting issues in arbitration. You can't change it. What? You go back to who? You can't go back to ICANN. No one will agree to anything in ICANN. You go back to WIPO, but WIPO has now endorsed the jurisprudence in its jurisprudential overview. What? Back? How can you go back? There's no authority to go back. The only authority that there could ever be is the same authority that's been developed by the panelists. Some special Einstein of UDRP comes up with an authority that's so convincing to everyone, that they say, why didn't we think of this before? And it changes course. In the retroactive bad faith that a number of panelists were applauding and thought it was the cat's meow, was rejected by the authoritative majority of panelists. And WIPO, in its 2011 overview, thought, well, this was something. This was going to go somewhere. By 2017, rejected totally. Just as an NB, just rejected. I mean, it's so it only if some authority so great, a David Bernstein plus comes in with a decision of such magnitude and convincingness, such persuasion that everyone wants to follow it. We have what we have, folks. We have a jurisprudence, and that's the.
It's been fantastic today. Before we got a couple more minutes, Jerry. Before we go, I have a question for you, but I want to. Okay. We're going to end on talking about the inaugural Levine lecture that's going to happen this Thursday. But first, I wanted to ask you, what can you tell us about the book you're working on?
Okay, so I'm collaborating with a real litigator. I left my litigation practice many years ago, who litigates in the ACPA area, in the trademark and ACPA area, David Weslow. And David and I are preparing a treatise. We're calling it a guide, but it's basically a treatise on the ACPA that discusses all of the issues, many of the issues I discussed in UDRP, discusses all of the issues that have been are present in the ACPA jurisprudence. One area of which, of course, is the UDRP, but the UDRP appeals to the ACPA is a small area of the ACPA. In this area, as in the UDRP, the law is developed by folks. It's not developed by the Supreme Court, let me tell you that. And it's basically not developed by the except in one instance, a very important instance for investors. The law is not made in the circuit courts. It's made in the district courts. In the one area in which it really is made in the circuit courts has to do with creation date. The Ninth Circuit has developed a jurisprudence that looks to the creation date of the domain name. And the third, 11th, most likely the 7th, and the four circuits hold that you look only at the date of the acquisition of the domain name, which of course is, if you wanted to categorize the UDRP, is a Third Circuit regime. Am I right, Jeffrey?
Yeah, I mean, that is definitely a hot topic. So I'm looking forward to hearing what you all say about that. When can we expect this new treatise?
Well, it's I'm working my way through in the editing process, and as I chapter by chapter send it to David, he has to work through it. I think it would take a year for him to work his way through my edited chapters.
And really quick, are there any cases currently that we should all be kind of keeping our eyes upon, or is it pretty, is it a dull time for ACPA cases?
Actually, it's our good and loving friend who died a few months ago, Howard New, had a case that he lost in Florida, and that case was, quote, appealed. I always put this appealed in quotes because it's actually not appeal. It's actually a new case in the district court, but it was appealed, and it's most likely the way it's going. It's going in favor of the domain registrant. I forget whether it's now summary. I forget whether summary judgment has actually been granted, but so that's something to look to the end result of. I'm sure it's going to be summary judgment in favor of the domain owner, which means that the UDRP award will be abrogated. Now, I just got an email. Well, our group, the Jerry's call, just got an email from a terrific list who found in favor of the four-letter domain, and he just informs us that's now being appealed by the trademark owner. So, Anu, Jeffrey, do you recognize it? AUNU, was it something like that?
AHNU. Yeah, that was
AHNU. So we now have a new case that's suddenly been filed with the ACPA that we have to keep our eyes on. It happens to be I think it's Chinese investor, and this is a problem.
yes.
Because it's most likely, although I mean we only have the complaint right now, but it's most likely this is going to be what's called an in rem action, and although Louisiana, what is it? The Fifth Circuit, Jeffrey, Louisiana. The Fifth Circuit doesn't have any law on this issue. Will it follow the Third Circuit or will it follow the Ninth Circuit? Ultimately, but if it follows the Fourth Circuit with PRU.com, that investor is out of luck.
Well, I sure hope. I mean, thanks for sharing about your future book, Jerry. I was going to mention good. At least it gives me time to finish this one, so I don't need a year. But because we got to have you back to talk about, like we normally do on domain name law, specific cases. We go over specific cases, and I like going over some of the court cases, like this one that AHNU.com. Definitely want to take a look at that, and maybe when you revisit us sometime, we can talk about that and the ALO.com case, because very similar. These are in rem cases about valuable domain names, and let me tell you, domain investors are interested. We're interested in that. So before we shut it down today, Jerry, I want to ask you about this call on Thursday. It's your inaugural Levine call. It's Tony Willoughby is going to be the focus, or the gentleman that I guess is the focus of this call. But tell us about this Levine lecture. What are you doing here?
Well, I really can't claim invention here. Where are you?
I'm right here. Yeah, you see me?
I'm just looking to see where Zach is.
He's long gone.
He's long gone. Okay. So Zach and his cohorts, Nat and I'm just trying to remember who else. So they were kind enough to honor me with a lifetime award last year, and they were also going to throw in an annual Levine lecture. I said that's fine, but I don't want to give a lecture annually. I'm getting a little bit well, age wears you down a little bit. But I suggested that the first generation of panelists should be called somebody, but this was all Nat. This was all Nat's. This was all not well, Nat probably and Zach. This is all there. So if you want to make any complaints, you have to complain to Zach.
Well, it's an honor well deserved. I mean, if there's been anyone that's been so influential over the jurisprudence and in this area, Jerry, it's you. And getting that lifetime achievement award is the smallest thing that we could all do to honor you.
Anyway,
for those,
thank all,
go ahead, Jerry.
No, I was going to say, I just thank all my friends here. This is a project that in a sense, a never-ending project. It's called education. It's a never-ending project. Steve has written about the brand side, what brand side people should do, where they go astray and so on. And the ICA digests are influential. It seems to me it's a never-ending project. For me, the ACPA is the next one. But if there's years left, there's more to do.
Well,
right, Jeffrey?
Thank
Todd?
you. Thanks, Jerry. And thank you to my co-host, Jeff Neuman and David Michaels. I wanted to say, if you want to join, join the lecture, you want to listen in, you can go to dnlshow.com. We have the link there. Just click show information. More importantly, you can go to internetcommerce.org and they have the link there. But Mr. Tony Willoughby is going to be the one giving the lecture. I know it's at 9:30 my time here in LA, 12:30 in New York City, and that's on Thursday. So go to internetcommerce.org. You can get all the information you want there. Yeah, and I wanted to mention about, Jerry, when you brought up the first generation of these panelists, you brought up several times how they really have developed the law, basically developed the secondary market for domain name investors by their rulings. And it really is important. I mean, they're advocates, a lot of them, most of them, I will say, advocates for us domain name investors. So I think a lot of domain investors, if you happen to watch this on replay, be sure and check this out Thursday morning. That's the 18th, 9:30 Pacific time, 12:30 Eastern time, and you can get all the information at internetcommerce.org. Today, we had a very special guest and a great time. Thank you, Mr. Gerald Levine, for joining us. That's going to be it for today. Have a great afternoon.